recommendations of the Turkel Commission, and with your permission, I will say a few words about the work of the Turkel Commission itself and then address the status of the implementation of its recommendations. The Turkel Commission was established by the government of Israel on June 2010 and was tasked, inter alia, with reviewing Israel's investigation mechanisms. The Commission undertook the task of identifying the standards for investigations of alleged violations of the rules of armed conflict as derived from international law. After carefully examining the Israeli system of investigations, the Commission concluded that the system generally complies with Israel's obligation under international law. The Commission also included a section of suggested recommendations for how to improve the Israeli system with the ultimate goal of implementing best practices in the field. The Commission was headed by retired Israel Supreme Court Justice Yaakov Tirkel and was composed of Israeli experts in the fields of law, diplomacy, and security, as well as esteemed foreign observers, Lord David Trimble from the United Kingdom and Professor Tim McCormick from Australia, who replaced Brigadier General Ken Watkin from Canada. The Commission was also assisted in its work by a number of renowned international legal experts, including Professor Klaus Kress from the University of Cologne, Professor Gabriela Blum from Harvard University, and Professor Michael Schmidt, who assisted the Commission prior to his appointment as Chair of International Law at the U.S. Naval War College. The Commission's comprehensive report will hopefully serve as an important milestone for the continued development of investigation standards under the laws of armed conflict. Before this report was written, there was only limited analysis worldwide about the nature and scope of the obligation to investigate alleged violations of the laws of armed conflict. The innovative work of the Turkel Commission provides valuable information and analysis, creating a strong knowledge base and important precedent in this relatively new and dynamic area of international law. The work of the Turkel Commission may also prove useful to other nations with active militaries, as well as to the international law community as a whole. I'm not going to go into detail into the analysis into the substance of the analysis that the Turkel Commission conducted. I will just say that this analysis was conducted according to a strict methodology. The questions that the Commission considered were examined first according to the relevant rules of international law. Next, they were examined on the basis of an extensive comparative analysis with the mechanisms for examination and investigation employed in 6 central countries based on expert surveys commissioned from reputable national experts. Finally, the Commission examined the way in which the questions are applied in Israel based on the extensive written and oral submissions it received from a myriad of government and security officials, NGOs, and Israeli and foreign legal scholars. In its conclusion, the report included recommendations with regard to each of the 4 questions that the Commission posed. These recommendations aimed to improve the mechanisms in Israel and bring Israel's practice in line with best practices in this field. Some of the Turkel Commission's recommendations have already been implemented. Other recommendations, which require more complex legislative, regulatory, or procedural changes, are subject to an ongoing process. This process, I should say here, in January of 2014, the government appointed an implementation committee that is headed by Dr. Joseph Chekanover and has additional members of senior officials from the relevant stakeholders in government. I'm one of the members of this implementation committee. We were given 9 months to review the report and make practical recommendations for the government with respect to its implementation. So the effort is ongoing. I can say that the Commission has put extensive work into this review process, and I hope that we will be able to produce our recommendations to the government very soon. However, in the course of our work, we have already, or the government has already implemented a number of the recommendations I've referred earlier, and I will speak about it in a few minutes in greater length to the issue of the investigations with respect to the Israel Security Agency. But I will mention here, and I will also refer in a few minutes to some issues related to some recommendations in the field of legislation. But I do want to mention here one or a series of recommendations that were already implemented and I think are very important. And these are the recommendations that relate to how Israel investigates allegations relating to misconduct of its armed forces. In this respect, the most prominent recommendation is recommendation number 5. And this recommendation dealt with the issue of the mechanism for investigating these allegations, where the Turkel Commission recommended the establishment of a mechanism called an FFA, or Fact-Finding Assessment Mechanism, that will deal with the issue I think that you've mentioned, that was mentioned here in another question, the question of how one gathers the facts that the Military Advocate General needs in order to decide whether it is warranted to open a criminal investigation when a complaint is filed. Previously, this was done through the operational debriefing, and the committee recommended here to adopt a different mechanism. And this recommendation was implemented in full, and I will speak here about the principles of this mechanism, and Mr. Neumann later on can describe in greater detail exactly the details of how this mechanism operates. But as the Commission recommended, this is a mechanism that operates at a very senior level. So the people that do this fact-finding are at very senior commanders at the level of a major general, or between a colonel and a major general. They are not part of the chain of command in any way. So these are people that did not participate in any way in the specific operation or in the activity that is being investigated. This deals with the issue of independence that was raised here in the question. The Commission spoke of the expertise that needs to be within this mechanism, recommended that there will be individuals there with expertise in the operational, legal, and investigation fields. And the mechanism as implemented has exactly this. The people that are members of this mechanism have operational expertise that is necessary if you deal with issues of artillery. So you want to have someone that understands with respect to artillery, but also lawyers and also people with experience in investigation, foreign investigators that were recruited to this mechanism that have many years of experience in investigations. And these teams, and in addition, there is an international law advisor that is part of this mechanism that provides this mechanism advice with respect to international law. This is in addition to the legal expertise that exists in each and any of the teams. The work of this FFA mechanism is guided by the Military Advocate General. So the Military Advocate General can direct the team and ask what issues, what aspects need to be reviewed and addressed. And if this fact-finding mechanism provides the information to the Military Advocate General and the Military Advocate General feels that he needs additional information in order to decide whether this should go to a criminal investigation, again, he can ask the mechanism to complement its work. The mechanism was given, this mechanism is a permanent mechanism. It's not just for this particular point in time. It was given powers, so it doesn't only have powers to interview soldiers, but it can also interview civilians, the complainants. It can gather factual evidence, material evidence, and it was allocated very significant resources in order to deal with the issue that was also raised by the Turkel Commission of the time that it takes to do this work. And Mr. Neumann will be able to provide some information also, even comparatively, how quickly this mechanism already works. I think that already at this point, out of 99 cases, I think that were referred to this mechanism to collect information. In 47 cases, it has already been able to complete its initial assessment and provide the information to the Military Advocate General. So this is one example of I think, full implementation of a very important aspect of the Turkel Commission's report. There are other aspects, but as some of them deal with the issues, with the issue of Israel Security Agency investigations, I think I will refer to them as I speak later on the Israeli Security Agency investigations. And again, as I said, the work of this team that is supposed to make the recommendations of how practically to implement the report is continuing, and hopefully, I hope that within not too long, hopefully within maybe by the end of the year or shortly thereafter, we will be able to present our practical recommendations to the government and move on with the additional issues of implementation. I would like to say a few words, with your permission, in response to Mr. Kailin's questions with respect to the issue of individuals crossing the border. You have asked many questions. I will try to respond to the best of my ability to the key issues that you have raised. First of all, you have asked, when these individuals cross the border, can they make an asylum application? And I think the answer is yes, but I need to explain that in the sense that these people, they do not come to a border crossing, right? It's not that they come to an airport like sometimes it happens in other countries, and then they have no documentation or no, and the process begins. They just cross. Now they cross the fence, but in the past they just cross in the desert until someone finds them. Either no one found them or someone finds them, be it a force, an IDF force or a police force, and then, as things are at the moment, they are captured and they are provisionally detained. Right? In the course of this detention, this provisional detention, they can submit an asylum application. Right? And so far, I think about 4,500 applications have already been submitted, either at this initial stage or later on today, either from, I would say, the streets of Tel Aviv or in Israel, or from the facility, the open facility, what is the so-called open facility in Cholot. So I hope this clarifies this point. I think it's an important one. The other question was, what happens if someone assaults them, not on their way in Sinai, but when they're held by Israeli authorities or when they're present in Israel? Clearly, the mechanisms that exist in Israel to deal with assault apply in the same way when the issue is an assault of a person that is present unlawfully. So which mechanism exactly would apply depends on who holds that person at that moment. If that person is held by the Israeli prison service, there is a mechanism, a specific mechanism that deals with complaints with respect to prison staff. If that person in that moment was held by the IDF squad that captured him, and the complaint is against something an IDF person has done, so there is a mechanism within the military. And if the person was held by the police, so there is a mechanism within the Ministry of Justice. Now, this applies generally. These mechanisms, they're not special mechanisms for this particular purpose. These are mechanisms that apply generally to investigation of allegations against brutality of police officers, or against brutality by IDF personnel, or against against brutality by people at the Israeli prison service. If we had more time, I could elaborate about each and every single mechanism, but I think I prefer, unless you will insist, I think I prefer to respond to more questions because many were raised, and I think many were important. With respect to the issue of the timetable, with what is going to happen now, I wish I could say more, because it's the timing of this session. We did not. It was not planned to take place exactly a few days after the Supreme Court has ruled on the unconstitutionality of the previous arrangement. In all likelihood, the government will, and I think this is called for also in a way by the judgment of the Supreme Court, the government will need to present an alternative arrangement, and it will need to be done through legislation. Obviously, our view at the Ministry of Justice, this arrangement will, of course, need to comply with the direction of our Supreme Court, that I think said very clear things as to what is expected from a new legal arrangement of this matter. But of course, it will be irresponsible for me to predict what will be the result of a legislative process. I can only say, at this stage, what we are hoping or planning to do, but the legislative process is a legislative process. It represents a lot of interest and debate. So again, I'm really trying to be as responsive as I can, but also to be responsible in my response, and not to promise things that I cannot promise. I hope that this comment, that this elaboration is somewhat helpful. You've mentioned the issue of non-refoulement, and again, I will repeat what was said earlier. Israel is fully committed to the non-refoulement principle. It is part of our internal law. It was adopted by our Supreme Court 20 years ago. We do not remove people to countries where there is a risk to their life. And the result of this is, in fact, for example, when people come from Eritrea, since we do not remove them, even if their asylum application is rejected, is something that would be similar to the protection that you've mentioned in Europe. So in essence, it's a type of temporary protection where the people can stay. They stay in Israel. They remain in Israel. We do not remove them to their countries. And we do not enforce. We do not enforce. They're not allowed to work. They do not have work permits, but we do not enforce that, and we've stated that to our Supreme Court. So they have the means of the ability to provide for their livelihood. And the previous arrangement was an effort to offer something else, a facility that will provide everything, all accommodations and food to these individuals, but with some conditions related to it. But as was noted here, our Supreme Court felt that we did not strike the right balance there, and we need to go back to the drawing board and try to devise a different solution that will balance all the very important and competing interests that are involved here, and I hope that we will be more successful this time in our effort. So I hope this is more helpful on the immigration issues, and I will move on to say a few things on the issue of on the questions related to the Israel Security Agency and its methods of investigation. Again, many questions were raised. I should say at the outset, I completely reject the notion or the suggestion that was made here that there is a system that is designed to protect violations. This is absolutely incorrect, and I think some of the measures that I'm going to describe further demonstrate this. So, with respect to the definition of torture, as you've rightly noted, we do believe that the aspects that are covered by the definition of torture under international law are also covered by our legislation. But having said that, the Turkel Commission has, in one of its recommendations, made a recommendation that we review this issue, the issue of the legislation with respect to we reviewed the possibility of including an offense of torture as part of our legislation. This issue is being considered by this implementation committee of which I'm a member. And I think that is as much as I can say at the moment. I think this issue is given serious consideration. And even though I think that under the present situation, many of the particular issues that were raised are covered and are given full response by the present state of legislation, we will still see what the bottom line of these discussions in the implementation committee would be. I do want to say you've provided some examples. I assume that some of them are theoretical examples. There is I am not aware in any way of Israel Security Agency personnel committing sexual assaults or threatening with sexual assaults or any of these sorts. I just feel a need to completely reject that outright, this notion here. Another issue, and the same is true also with respect to the issue of the audiovisual documentation. This is also included in the Turkel Commission's recommendations, and as was noted here, it is a complicated issue that combines various interests and concerns, and what I can say now is that we are endeavoring to find an appropriate mechanism to balance between the different concerns that are relevant to this issue, and again the matter will be addressed in the report that will come from the implementation team for the Turkel Commission. One thing that I can already report in full that is what I started describing earlier with respect to the inspector of complaints against Israel Security Agency interrogators, and this is largely because we have already fully implemented these recommendations. The recommendation of the Turkel Commission there was that we transfer this function from which used to be within the Israel Security Agency or authority to the Ministry of Justice, and in fact, the recommendations, the Turkel Commission has already built their own on decisions that were made already earlier by the Attorney General to do exactly that, and we have taken advantage of the opportunity not just to transfer the function from the Israel Security Agency to the Ministry of Justice, but to conduct a complete reform or a major reform in the function, in the sense that, first of all, we have appointed a person who was the former chief military prosecutor of the IDF. I think any person who knows her knows she's a person of great integrity and authority. Certainly a very senior person to take this position, and highly professional and experienced. She was appointed in June 2013, but there was a process also until she took over the position, because we've also added additional positions of investigators and others to the mechanism. We've also transferred the facility from where it was located previously to within the Ministry of Justice. And so the logistics has taken some time, and it was only in mid-2014 that the logistical process was completed. She started doing some work before, but it's still relatively in very early days. One thing that was already done immediately upon, I think shortly after her appointment, she initiated contact with the relevant non-governmental organizations and the International Committee of the Red Cross. She holds meetings with these organizations that are the organizations that submit complaints with a view to having greater transparency. And these, I think, meetings also led to another improvement. We have seen in the past some reluctance on behalf of some of the complainants to provide testimony. So the complaint would be filed, but when we were asking for the complainant to provide testimony or evidence, the complainant often would refuse to provide testimony, which would be fatal to the possibility to investigate, or almost fatal to the possibility to investigate the matter. Through this cooperation with civil society, we were now able to secure a possibility for complainants to come to the district coordination office in the West Bank, and the inspector comes there also, and she takes the evidence there. She also allowed the presence of NGOs, of the NGO representing that individual in the taking of the evidence to provide further assurance to the complainant. And using the resources in this period of transfer, a certain gap was created in the investigation of pending cases. One issue that she has taken on and she's very committed to is to try and close that gap. Hopefully by the end of the year she will be able to close the gap of a previous year. I hope that all of this reflects the commitment that we have in the Ministry of Justice and in the government as a whole to have to have this issue improved and to work towards greater transparency and efficiency of this mechanism. If I may move on to the issue of ideologically motivated violence, mostly in the West Bank, but not only. This is again an issue of great concern to us in the government. It is a deplorable. These are deplorable actions, and the government has taken very serious steps. I think there was a peak at some point in 2012, 2013, and I think the government has taken resolute and very serious measures in response, which in my view were quite effective because we see great reduction in this phenomenon in 2014. I will just briefly state some of the measures that the government has taken. We've appointed an interministerial team to deal with ideologically motivated crimes with representatives from the State Attorney's Office. It is headed by the Deputy State Attorney, from Israel's security agency, from the police, and from the IDF. That this team meets regularly and coordinates all the enforcement activity between the relevant bodies. I've been informed that it met at least 6 times in the last year, and it gives the operative directions to the various agencies that deal with the matter. In addition, due to the importance of dealing with these matters, periodic meetings are held, headed by the Minister of Public Security and the Minister of Justice. a special regional unit was established within the police for handling ideologically motivated crimes. It's part of the Israeli police in the West Bank. It's a large force. In Israel, I mean, it was already allocated, I think, 30 officers, and I think 50 additional officers are to be allocated. In Israeli terms, it's a very large force. This force conducted dozens of activities during, conducts dozens of activities during each year. Open activity, covert activity. Some of it is in areas where there is friction, and it operates with a view to investigate, but also with a view to prevent violations, and it also has a power to take certain preventative measures against individuals with respect to whom we have intelligence information that they intend to act not according to the law. In addition, we have established a special desk in the Police Regional Intelligence Department, which is in charge with obtaining intelligence information regarding offenses that are conducted on ideological background, including public disorder and attacks against Palestinians. Public disorder offenses and attacks against Palestinians are given high priority, and the appropriate resources are allocated, and they are investigated by special teams which were formed specifically to handle these cases in the investigation units in the region. In terms of our prosecutorial policies, we have reviewed those. We are prosecuting these people in addition for the specific offense. When it is a hate crime, there is a provision in our penal code that allows for double to double the penalty. The state attorney issued instructions that in every case where it is possible to prosecute in using this provision, we do that. We insist on very severe penalties within our court systems. I can read to you from one of the indictments. The actions described in this indictment join a long list of similar criminal activities that took place in recent years at night time, both in Israel and in the West Bank, that concerns the random damage to property and religious structures, sometimes as a response to the actions of state authorities, and this due to their mere belonging to the Arab population. These actions included also spray painting of various slurs aimed at making it clear that the perpetrators are Jewish. The actions described in this indictment are sufficient to cause resentment among persons of the Arab and Muslim minorities and may lead to attacks and acts of vengeance against security forces as well as Jews in both Israel and in the West Bank, as well as severely harm the state of Israel, as well as its international reputation. We are very insistent that this is something that we would like to fight, and I think we have been relatively successful in this. If we look at the number of occurrences in this present years, I have here examples of indictments, specific examples of indictments, but I think I will not go into this again with the interests of covering many of the other issues that some of the members of this committee have raised. I hope you will find this helpful. I'm passing now the floor to Mr. Neumann, and I thank you very much. Thank you.
Thank you. Actually, there are a lot of things that I was asked to refer to, so I hope I will not miss one of the things. And there is also a lot of data that I have, and I'll mention the details that I have, taken into account the time frame that is given to me. I will start with relation to the situation in the Gaza, the blockade, the situations, and Israeli efforts to facilitate and to help the humanitarian situation in Gaza. At first, I must emphasize that according to Israeli view, the Gaza Strip has not been under Israeli control since September 12, 2005, when the last of Israel IDF forces left the area following the implementation of Israel disengagement initiative. Since then, it has been clear that Israel does not exert effective control in the Gaza Strip. Any claim to the contrary clearly distorts and misapplies the established rules of international law regarding the beginning and end of belligerent occupation and ignores the factual reality regarding Israel's capacity for effective control in Gaza. Indeed, following Hamas' violent takeover on the Gaza Strip at 2007, the area has turned into a hostile zone similar in almost every aspect to an enemy state engaged in war against the State of Israel. As a consequence of Israel's disengagement and lack of effective control, the Israeli High Court of Justice affirmed in 2007 that Israel does not have a general duty to ensure the welfare of the population of the Gaza Strip. Rather, Israel's obligation towards the Gaza Strip stem from the continuing state of armed conflict with the Hamas terrorist organization and other terrorist organizations in Gaza. However, in spite of the threats that is posed by Hamas towards Israel, the IDF and the Israeli civilians, as we have noticed in the last operation, even over the course of the last operation in Gaza, Israel made great efforts to facilitate the provision of the Gazan civilian population needs and to minimize any harm befalling it as a result of the hostilities. In addition to providing, where feasible, advanced warnings to the civilian populations of IDF activity, over the course of the operation, Israel made extensive efforts to address the humanitarian needs of the civilian population in the Gaza Strip. It should be stressed that these efforts were significantly beyond the requirements of international humanitarian law, and Israel sought to maintain them even as crossing points and humanitarian pauses were made the subject of heavy rocket and mortar fire by Hamas and other terrorist organizations. Israeli humanitarian efforts comprised several components, which included inter alia, facilitating the continuous supply of humanitarian aid through the crossing points, such as food, medical supplies, and fuel. Over the course of the operation itself, Israel facilitated the passage of total of more than 5,000 trucks carrying more than 122,000 tons of supplies through the Kerem Shalom crossing, and this includes 74 tons of food supplies, 25 tons of animal feed, etc. In addition, Israel, during the operation, included the unilateral suspension of military operations to enable resupply of the population and humanitarian relief activities. Moreover, the State of Israel also donated 20,000 food aid package and drinking water, as well as other required items such as electricity generators. Israel also carried out repairs and other measures to ensure the functioning of essential infrastructure in the Gaza Strip. Finally, Israel also undertook the provision of medical treatment of Palestinians at the crossing and in Israel. During the operation, a total of 607 patients from Gaza were evacuated via the Erez crossing for treatment in hospitals in Israel and the Palestinian Authority. The field hospital set up by the IDF at the Erez border crossing to facilitate care for wounded civilians from the Gaza Strip treated a further 51 patients. Israeli humanitarian efforts were further assisted by the presence of specially designated humanitarian affairs officers in combat units from the battalion level and up, who function as advisor to unit commanders regarding the presence of civilians or sensitive sites in the area of operations, assisted with the coordination of humanitarian movement at the tactical level, and helped commanders minimize the impact of the hostilities on the civilian population. As speakers of Arabic, these officers also facilitated communication between IDF forces on the ground and civilians in the combat zone. Meanwhile, through the operation, the terrorist movement Hamas incessantly targeted the crossing between Israel and the Gaza Strip, despite the fact that through this crossing, supplies were being delivered to its own civilians. In one such attack on the Erez crossing point, an Israeli man was killed by a Hamas mortar shell. These attacks had a very real impact. It should be noted that while the number of aid shipments authorized and coordinated by the IDF was 8,400, the number of trucks actually making the crossing was instead 5,600. This discrepancy was largely due to the incessant rocket and mortar fired by Hamas at the Kerem Shalom crossing. Furthermore, over the course of hostilities, Hamas refused countless ceasefire offers and violated orders, resuming hostilities with barrages of rockets fired into Israel. As we are talking about what is going to be forward, I would like to say that in light of Israel's sympathy for those civilians affected by the hostilities, Israel is continuing to implement its flexible policy regarding the movement of goods and people into and out of the Gaza Strip, despite the actions of the terrorist organizations Hamas, and even though Israel and its civilian population suffered tremendously as a result of the attack prior to and during the Operation Protective Edge. Moreover, a number of endeavors agreed upon with relevant UN agency and Palestinian Authority personnel are currently being promoted in order to facilitate the rehabilitation of the Gaza Strip subject to security consideration and requirements. For example, a defined mechanism has been created to allow for the entry of large amounts of aggregates, cements and other construction materials required for the reconstruction of civilian residences and public buildings, whilst providing the State of Israel with specific security assurances regarding the allocation process and reducing the risk that such materials will be used for terror activities as been done in the past. Additionally, the Israeli government has recently implemented a number of leniencies in regard to Gaza in connection with the movement of people and goods via Israel sovereign territory, such as the facilitating of family visits from the Gaza Strip to West Bank during the holiday season and visits to the Temple Mount for religious prayers for elderly Palestinians, and the facilitations of agricultural produce and fish from the Gaza Strip to be marketed in the West Bank. Israel is currently contemplating a number of further adjustments subject to the stability of the security situation on the ground. With regard to the entry of people from the Gaza Strip into Israel, I would like to say that as affirmed by the High Court of Justice in numerous judgments, as with any states, foreigners do not have a legal right to enter Israel's sovereign territory. In light of the security situation in Gaza, this is especially true with regards to the entry of civilians from Gaza into Israel. Despite the lack of a legal right and the fact that the Gaza Strip is controlled, as I said before, by Hamas, Israel has chosen to take a calculated risk and allow for entry into its territory in humanitarian cases primarily, such as those needing urgent medical care. It should once again be stressed that this policy goes beyond Israel's legal obligation. As part of this policy, Israel allows for the entry of businessmen whose crossing facilitates the transfer of goods into the Gaza Strip and conducts of its development, as well as those working for international organizations. Now, I have a lot of data regarding this, but I'm not sure I have enough time to go into it. I would like just to add that in addition for this, in the past year, the residents of the Gaza Strip could also travel to Egypt and through there to the rest of the world through the Rafah crossing, which is not controlled by Israel in any way, but rather exclusively by Egypt on one side and Hamas on the other. To the best of our knowledge, during 2012, approximately 40,000 people crossed through the Rafah crossing on average per month. I will not go into the details, I will just add regarding the questions of the water supply into Gaza. The agreement on the Gaza Strip and the Jericho area in 1994 relates to the question of water in the Gaza region. In the framework of the agreement, control over the water supply system in the Gaza Strip was transferred to the Palestinians, as was mentioned by the people who asked the question about Gaza. With regard to the Gaza, since the end of the disengagement process and up until the present date, all water supply and sewage systems in the Gaza Strip are under exclusive Palestinian control. The main source of water in Gaza is an aquifer located in the area which is not influenced by Israel, nor does it influence the water situation in Israel. With regard to it, it was agreed that the water 5 MCM per year would be supplied from Israel national water system at a price equal to the cost of the desalinated water plus transport. The supply pipeline for this purpose was laid by Israel up to the border with the Gaza Strip. It is important to stress that the quality of the water supplied by Israel to the Palestinians is identical to the quality of the water provided in Israel and meets all international standards. In the Gaza Strip, where the Palestinians are in full control, over 6,000 unapproved wells were drilled immediately following Israel's withdrawal in 2005, causing a severe drop in water levels and seriously harming the quality of water in the Gaza aquifer and the general Gaza water economy. This situation is ongoing and is even intensifying. The total damage caused is clear and is impossible to reverse. The grave situation in the Gaza Strip remains, and the only ones affected are the Gaza residents. And for this, I think that the solution that is what is being now talked about is about taking care of transfer more water to Gaza through the not by Israel, but by the settlement. Regarding the questions that was asked, and Roy refer to it in his speech, the IDF policy regarding the investigations of an operational nature. The IDF views violations of the legal rules governing the conduct of soldiers during operations at all levels of intensity as a deplorable phenomena that requires the relevant authorities' utmost attention. In accordance with that view, it is the IDF unequivocal and clear policy that all suspicions will be thorough and efficiently examined and proper measures are taken when found justifiable. It is the IDF official policy that when such claim for alleged violation gives rise to a prima facie reasonable and reliable suspicion that a criminal offense may have been committed, the MAG, the Military Advocate General, will order the immediate opening of a criminal investigation. Although, in the case in which death of uninvolved Palestinian occurred during military operation in the West Bank, an immediate criminal investigation will be initiated. In other cases where there is not reasonable suspicion of criminal misconduct or where the complaint may not be from a sufficiently reliable source, the complaints are examined using a fact-finding assessment in order to aid the decision by the MAGCOR on initiating a criminal investigation. Unfortunately, many of the claims made against IDF soldiers operating in different fields are made anonymously at best or forwarded only to the different NGOs collecting such data without being referred to the proper authorities. Thus, in a lot of cases, it is almost impossible for us to deal with different allegations concerning impunity when the most basic requirement for giving us the proper data to examine these claims are lacking. If I just mention and give you the situation about the last operation in Gaza and how it is investigated, I would like to say that during the course of the operation, the Operation Protective Edge, the IDF Chief of Staff, Lieutenant General Benjamin Gantz, ordered that a general staff mechanism for fact-finding assessment will examine exceptional incidents that occurs during the operation. The mechanism is currently headed by Major General Noam Tibon and is comprised of a number of fact-finding assessment teams comprised primarily of high-ranking IDF reservist officers possessing operational expertise in a wide range of military areas such as artillery, intelligence, and aerial operations. The teams also contain members possessing both legal qualifications and professional experience in the field of investigations. Each team is led by a senior IDF officer with a rank ranging from colonel to major general. The teams are also provided with ongoing legal advice from our legal officers in the IDF MAGCOR, who have particular expertise and experience in international law. An additional senior officer from the IDF reserves with expertise in international law has also been appointed to assist the head of the FFA mechanism, the fact-finding assessment mechanism. None of the fact-finding assessment teams members served in the chain of command during Operation Protective Edge. This is, I will just continue with what Roy Shandov talks about the mechanism, the Turkish Commission, and how it was implemented during the operation. Now, the task of it is to collect information and relevant materials in order to determine the facts with respect to exceptional incidents that occurred during the operation. These efforts are intended to provide the Military Advocate General with as much factual information as possible in order to enable him to reach decisions regarding whether or not to open a criminal investigation, as well as for the purpose of a lesson learned process and the issuance of operational recommendations that will assist in preventing exceptional incidents in the future. Exceptional incidents examined by the FFA mechanism are those incidents where the MAG has decided that additional information is required in order to determine whether there exists reasonable ground for suspicion of a violation of the law which would justify a criminal investigation. All information and materials collated by the fact-finding assessment teams, as well as their findings, are provided to the MAG, who will decide in a reasoned decision on the appropriate action, whether to close the case, to recommend disciplinary measures, or to order the opening of criminal investigations to be conducted by the Military Police Criminal Investigation Division. Where necessary, the MAG may also order the fact-finding assessment team to collate additional information in order to compile a full factual understanding of a particular incident. The substance of the MAG decision are being publicized as they are being made, subject to restrictions under the law and limits pertaining to the security of classified information. Where individual complaints have been filed, updates regarding the MAG decision are being sent to the relevant person. In addition, in order to ensure transparency, updates regarding the MAG decision are being publicized periodically, and such updates may be found on the MAG website. The MAG decisions may be challenged before the Attorney General, and as with all other decisions by state authorities, are subject to judicial review by the Israeli High Court of Justice. The fact-finding assessment teams were instructed to complete their assignments within a short time frame in order to ensure prompt and effective examination. To this end, and to ensure the thoroughness of the assessment, the teams have been provided with the requisite resources. Further, the teams have been invested with broad-ranging powers to acquire the provision of materials from all branches of the IDF and to collate materials from external persons, including civilian witness testimony. All IDF soldiers are required by law to cooperate with the fact-finding assessment teams and to provide any relevant information they may possess. Statements provided to the fact-finding assessment teams, as well as any materials these teams may produce, are privileged under the law. Thus far, more than 100 exceptional incidents have been referred to the FFA mechanism for assessment. Such incidents include events allegedly resulting in significant and unanticipated civilian harm, and events where military activity allegedly result in damage to medical or UN facilities. Currently, the FFA mechanism has completed its work with regard to 47 incidents which have been referred back to the MAG for decision. Following the MAG examination of the information and materials collected by the FFA mechanism, as well as its finding, the MAG decided to return 20 incidents to the FFA for further assessment. Furthermore, the MAG decided to close the case with regard to 7 of these incidents and has ordered criminal investigation with regard to 2 of the incidents. The remaining incidents are pending decision. Allegations which prima facie and without the need for additional examination raise a reasonable suspicion of a violation of the law are generally transferred upon the decision of the MAG directly for a criminal investigation and are not examined by the FFA mechanism. As of the date of this release, the MAG has ordered the immediate opening of criminal investigation with regard to 6 incidents. In this regard, I would like to say that there are no execution of IDF soldiers within Agada. The IDF soldiers are not executed anyone. The executions were being made only by the Hamas to the people in the Gaza. What we are doing is in accordance with international law, and if there are suspicions that something is not in accordance with the law, a complaint might be given, and we'll examine if it was in accordance with the law or not. It's also worth to mention that in war there are cases in which civilians might get hurt as collateral damage, and this fact by itself does not mean or suggest that the violation of international law has been made. The quick establishment of the FFA mechanism, including its activation in the midst of the Operation Protective Edge and the allocation to it of the required resources, attests to the IDF's continued commitment to the rule of law and to its commitment to international law obligation. Now, I'll refer in some details about the situation, about the data regarding the complaints that were given to the IDF in 2003. with regard in general and with regard to the Central Command's area in particular. In the year 2013, the military advocate for operational affairs of the MEG received approximately 220 complaints in regard to its operational activities across the different commands. Of these reports, more than half resulted in the opening of a criminal investigation. About 60 were closed, and the others are being pending decision or being still in the process of deciding what need to be done with them. Of these complaints, 164 related to the events taking place within the Central Command's area of operation, namely the West Bank. By the nature of the type and extent of the operations undertaken by the Central Command and the level of its interaction with the Palestinian population, this figure represents the bulk of the reports received by the IDF in regard to its operational activities. As regarded to investigation into fatal incidents occurring within the West Bank in 2013, there were a total of 21 incidents resulting in 26 deaths over the course of the year. Of this, a criminal investigation was opened immediately in regard to 12. Additionally, during 2013, 7 indictments were filed against soldiers of different ranks, including 2 officers, one of which is ranked colonel. An additional 3 indictments were filed concerning incidents dated from 2013 at the beginning of at the beginning of 2014. 8 of the total 10 were concerning violent acts against Palestinians. 2 cases are worth noticing. Colonel Shalom Eisner was indicted and subsequently convicted of physically attacking a foreign national using the butt of his personal weapon during a demonstration around the Palestinian village of Aluja. Following his conviction, he was sentenced for 2 months imprisonment, and the sergeant was indicted and subsequently convicted of negligent manslaughter following the shooting and killing of a person trying to cross the security barrier into Israel, occurred in January 2013. Following his conviction, he was sentenced to 7 months imprisonment. Now, I will go further to the questions that were asked regarding minors and the way that they are being dealt in the military court system. The State of Israel attached great importance to strengthening and promoting the protection granted to minors in the military justice system in the West Bank, while simultaneously taking into consideration the unique circumstances and the security situation in the West Bank. The nature of the Israeli-Palestinian conflict in the West Bank, together with the severity of crimes committed there and their often ideologically motivated character, create a unique set of demands from the criminal justice system in the West Bank. Moreover, law enforcement operations in the West Bank take place in highly complex and complicated setting inherent to an armed struggle. Israeli law enforcement activities must be carried out in hostile Palestinian towns and villages where every law enforcement activity has the potential of leading to wide-scale armed and violent riots. The presence of terrorist organizations is widely felt in the West Bank. One of their key motives is to instill a sense of hatred against the State of Israel and its citizens through indoctrination of the population starting at preschool and continue all the way through to adulthood. This education leads to regular violent activities ranging from throwing stones and Molotov cocktails to armed attacks and violent terrorist activity, targeted against military personnel and civilians alike. Unfortunately, minors play a significant part in these acts. However, the danger and damage caused by their action is usually the same as if the acts are performed by adults. Consequently, in 2013, of the 470 indictments filed against minors, 54% relate to throwing, 14% to throwing Molotov cocktails, 23% to offenses pertaining to the possession and use of paraphernalia, and there are a lot of data that I will say from you. Just want to mention 3 main example of cases in which minors were involved in. One of them is in March 2015 by Hakim Awad, 17-year-old minor. He was confessed he's murdered 5 members of Fogel family. There are several more cases in which minors commit attacks against people which result in the death of them. Now, regarding the things that we are doing in order to give much more rights and to make sure that the minorities get the treatment that, and I would like to say that there is a real process of review of the rights of the minors, and there were a lot of things and a lot of amendments were made to the law in the West Bank in order to give much more rights to minors. Some of them were just mentioned: the establishment of the juvenile military court, raising the age of minority, etc. I will not go into all the details. I would just like to say that there is a huge progress in this, and there are a lot of things that have been done in this regard. To some of them we refer in other documents. I'm not have enough time, so I will not go into details about the. I will just address one more issue that I was asked to about the removal of Gazan residents from the West Bank. Many of the illegal residents in the West Bank are Palestinians from the Gaza Strip, and it is the current policy of the State of Israel to refrain from removing from the West Bank these Palestinians who entered the West Bank prior to the 12th of September 2005, unless there is an individual security risk posed by their stay in the area. All the rest, there might be might be ordered to remove to Gaza. However, there is a due process in order to make sure that they get all the rights that they needed to be given to them, and the due process is in this area. Nevertheless, in recent years, Israel has accorded permanent residency to thousands of Gazan residents who for years has resided illegally in the West Bank as a part of a goodwill gesture to the Palestinian Authority within the framework of relation between the site. And really the last one, and the last minute that I have, will be about the access to the holy site. And I would just say that freedom of religion is also upheld by the Israeli authorities in the West Bank, within whose areas of responsibility falls the safekeeping and maintenance of access to holy places subject to security consideration. Generally, Israel grants permits for Muslim residents in the West Bank to men over the age of 55 and women over the age of 45 to enter Israel to participate in the prayers on the Temple Mount on Fridays. Furthermore, during the month of Ramadan in 2013, the criteria for entry were shifted, and as a result, over 1 million Palestinians were granted permission to enter Israel, quite a few for religious purposes such as praying on the Temple Mount. To alleviate the logistical challenges posed by the entrance of over 1 million Palestinian visitors, the operations hours of the crossing points were extended, numerous permits were given for family visit in Israel, and the internal crossing in the West Bank were opened so as to facilitate the entrance of thousands of vehicles. Regrettably, last Ramadan overlapped with Operation Brothers Keepers in the West Bank, and the security situation on the ground did not allow for the easing of the security restriction as was the case last year. I will end by this. Thank you.
Ms. Marks.
Very briefly, a number of issues that arose I'd like to address. In relation to Israel's very active civil society. We have hundreds of NGOs active in a large number of issues, hundreds of members of international human rights organizations that are very active in Israel on a routine basis. There are no legal restrictions on the right of organizations to engage in activities for the promotion and observance of human rights. For legal purposes, they are indistinguishable from any other organization. To the extent that they are registered as associations, they must comply with applicable law. Indeed, the activities, as arose in one of the questions, indeed the activities of NGOs, and specifically the non-transparent nature of foreign government funding of NGOs operating in Israel, and concerns raised that it's used to interfere and influence in Israeli politics, are subject of public debate. The law that was referred to, the obligatory disclosure for receiving support by a foreign political entity law from 2011, stipulates that any association or company for the benefit of the public which receives a donation from a foreign political entity must notify the association's registrar with various requirements to publish for the benefit of the public the information that's received. This issue reflects law that was in existence prior to that law, in the law of associations, which has similar stipulations. And because of the shortness of time, I won't go into it too much, but I do want to stress that the law doesn't prohibit or impose any restriction on the receiving of the contributions themselves, and nor on the activities of the NGOs. There is nothing in the law to substantially change the current existing situation in Israel, and nothing in the law to harm the democratic process or the standing of civil society and non-governmental organizations in any manner. There are currently, as I think was also referred to, a number of bills on this matter that are in discussion in the Knesset. The Israeli legislative process is complex. I mean, it is long and has many stages. Preliminary approval of the Speaker of the Knesset, various committees and the plenary's approval. This is a process that's ongoing in this particular regard, and it's aimed at ensuring that the final law reflects the will of the legislator. We were asked about the prevention of harming of the State of Israel by boycott law. As also because of the shortness of time, I just want to stress that this is a law which is intended to protect Israeli citizens from damages caused by organized boycotts, to guarantee that no use of public financial sources will be made in order to support activities that may harm Israeli citizens. But the act amounts to a civil tort. Nothing in it specifies a criminal offense. And it is as a whole pending. There are a number of petitions on this matter pending before the Supreme Court, and we're waiting for the Supreme Court's verdict. Two very brief additional issues. The issue of the Jews' residents of the Golan Heights was raised. To mention in this regard that the residents of the Golan Heights are citizens and residents in every regard, and they receive the same rights as any other resident or citizen in all aspects of life, including access to land, housing, basic services, and natural resources. Visitation by inmates, visitation of inmates by their families from the West Bank and Gaza. Very briefly, the State of Israel acknowledges the importance of maintaining family visitations, and it's stated so on a number of occasions to the Supreme Court. They allow such visitations when no security hindrance exists. And in fact, as far as the West Bank is concerned, there are thousands of visits authorized annually. Currently, due to security reasons that derived from the latest escalation between Israel and Hamas, the IDF halted the visits from the Gaza Strip. This is in review currently. The possibility of re-establishing such visits is being examined as part of the Israeli government's general deliberation on the wider situation. That's all.
Thank you. Very briefly, regarding settlements, every time the moment of truth arrived, Israel knew how to proceed and promote a constructive outcome. Following the peace accords with Egypt, Israel dismantled all its settlements in Sinai. In 2005, in the context of the disengagement plan, Israel dismantled all the settlements in the Gaza Strip, as well as a number of settlements on the West Bank, and evacuated all their inhabitants. The settlements are among the core issues to be discussed and resolved between the parties during the negotiations on a permanent agreement. Ms. Kremer.
Thank you. I will refer now to the security fence issues. Over the years, Palestinian terrorism has taken the lives of thousands of Israelis in brutal terrorist attacks. In order to secure the lives of its citizens, Israel has built a temporary, defensive, non-violent security fence. Since the fence has been constructed, the number of terrorist attacks has decreased significantly. It is the right of Israel, as well as its duty, to protect its civilians against security threats emanating from the territories. The legality of the construction of the fence was also affirmed by the Israeli High Court of Justice in numerous petitions. The decision to construct the security fence was made in direct response to the wave of terrorist attacks against Israel, which began in September 2000. For context, in the month of March 2002 alone, 135 Israeli civilians were murdered and 721 were injured in terrorist attacks. The fence is a temporary security measure and is not intended to annex territory. No changes have made to political boundaries, which remain a subject for negotiation between the parties. The route of the fence has been determined solely on the basis of security concerns and topographical considerations. In its ruling on the subject, the Israeli High Court of Justice has stated that the balance must be struck between Israel's obligation to protect its citizens from terrorism and the legitimate needs of the civilian population in the West Bank. Every segment of the fence, both planned and existing, have been subject to examination and approval by legal advisors prior to its construction, in accordance with the rules stipulated by the HCJ, as mentioned above. In order to minimize the necessity for land seizures within the West Bank, the fence was built on Israeli sovereign territory or state-owned lands rather than private lands, wherever security and topographical considerations allowed. Additionally, Israel makes great efforts to avoid separating landowners from their lands. Where such an outcome is unavoidable, agricultural gates allowing for farmers to cross into their land have been constructed. Moreover, in cases where the fence causes residents economic harm, those affected are entitled to compensation. The fence has proven to be extremely effective. According to the study complied by the Israeli Security Agency, the fence has dramatically impacted the ability of terrorists to cross into Israel in order to carry out terrorist attacks. The inescapable conclusion is that the security fence has played a major role in bringing about dramatic reduction in Palestinian terror and direct loss of lives on both sides. In its landmark decision regarding Bet Zurik village, the High Court of Justice clearly stated that both the consideration behind the decision to construct the fence and the considerations regarding the determination of its route are security-based. This position was reaffirmed by court in a number of other decisions. Since the construction of the fence began in 2002, around 170 petitions have been filed to the Israeli High Court of Justice, and were heard before it. In some cases, the court's ruling have called to changes to be made in the route of the fence. In other cases, the military commander unilaterally changed the route of the fence in light of the court's remarks during the proceedings. Additionally, during the course of proceedings before the court, special arrangements were often reached between the military commander and the petitioners, such as establishment of humanitarian routes, the allocation of alternate lands in place of the seized land, and the according of financial compensation. Since significant segments of the fence are located within the West Bank due to security concerns and topography of the area, a SIM zone was subsequently established over the area, which held within it privately owned Palestinian lands. Consequently, the establishment of the SIM zone impacted upon the freedom of movement of the local population. However, Israel had gone to a great length in order to minimize the impact on the SIM zone on the local population, particularly in regard to access and freedom of movement. Alterations were made in the arrangements applying to the SIM zone, and additional modifications are planned, including the construction of 14 roads to enable easier passage between Palestinian villages, as well as to facilitate Palestinian farmers' access to their agricultural lands, along with daily transportation of pupils from one side of the fence to their schools in the SIM zone to be funded by Israel. To ensure regular access and freedom of movement in accordance with the needs of the local population, 33 passageways were constructed in the fence, in addition to 32 daily agricultural gates and 42 seasonal agricultural gates. The Israeli High Court of Justice, in its jurisprudence, has addressed to the conclusion drawn by the ICJ advisory opinion regarding the legal consequences of the construction of a wall in the occupied territories. The court held that the ICJ advisory opinion as such does not obligate the High Court of Justice to determine that all the segments of the fence violate international law. The court also noted that while the ICJ accorded full weight to the rules of international law, it had relied on inaccurate, incomplete, and imbalanced assessments of the facts in order to reach its determinations. It seems that the ICJ advisory opinion suffers from a number of deficiencies. Firstly, the opinion reviewed the fence as a whole rather than reviewing it segment by segment as the High Court of Justice does. Secondly, the ICJ determined the primary objective of the fence to be political and therefore illegal, and failed to give adequate consideration, if any, to the terrorist threat Israel faced. Thus, the ICJ essentially overlooked the fundamental reason for the establishment of the fence. Thirdly, the High Court of Justice stated its disagreement with the conclusion drawn by the ICJ that Israel does not have the right to employ means of self-defense in the face of terror attacks by non-state entities in the context of an armed conflict. The High Court of Justice determined that in the case of the security fence, Regulation 43 of the Hague Regulations of 1907 authorizes and indeed obligates the military commander to take all necessary steps to preserve security, and that acts permitted under self-defense are included within such action. Thank you, and I would like to...
Ms. Tanner.
Okay. Hila?
Thank you, Chair. Thank you. Three last quick comments on the issue of the Fight Against Terrorism bill. This bill is undergoing currently almost weekly debates in the Knesset committee on this issue. The work preparation towards it includes a lot of both comparative and international law examination. The work there's a lot of work ahead. The final outcome will not be available at least for several more months, and I'm optimistic, to be honest. Regarding the question of the second protocol raised by the chairperson, the Israeli laws still have several provisions. Unfortunately, I don't have time to detail them. I will say that we've had many discussions on both the second protocol and the issue of the general moratorium on the death penalty. We feel that there's still legislation amendments that will need to take place before we can either join the protocol or fully join the moratorium, but this is being evaluated on a regular basis. And the last point regarding the issue of a divorce decree, the agreement is necessary by both the husband and the wife, regardless of who filed the request for a divorce. Thank you, Chair.
Thank you, all the members of the delegation. I'll say a word about where we are now in terms of the dialogue as part of my own wrap-up. So at this point, I'll invite the distinguished head of the delegation to give his closing remarks.
Thank you, Mr. Chairperson. I would like to thank you and the distinguished committee members for taking the time to meet with Israel's representatives, review its report, and provide valuable feedback to our delegation of experts. Our delegation came here today with the will to engage in a substantive and open dialogue, focusing its best efforts in answering the questions presented and participating actively in a review that will surely bear constructive and fruitful results. Israel places great importance on respect for human rights, and as was presented by our delegation today, has achieved significant developments in law and in practice. Since its establishment, Israel had to face many difficult and complex security challenges, which strained the delicate balance between effective steps necessary to overcome the various threats, along with the democratic state's basic obligation to protect the safety and well-being of its citizens and the protection of human rights. It is a delicate line, and we make strenuous efforts to respect it. As I said in my opening statement, Israel remains committed to peace. We are willing to make historic and painful compromises to realize the creation of a demilitarized Palestinian state living side by side with the Jewish state of Israel. Israelis and Palestinians will have to work together to resolve numerous complex problems. This will only be possible if our work is built on a foundation of truth, mutual recognition, and security. It will only be realized through direct bilateral negotiations between the parties. Israel wishes to reassure all present that all remarks and recommendations expressed by the honorable committee members shall be examined carefully and will be used to enhance and improve Israel's compliance with its commitments and obligations in the field of human rights. Thank you.
Thank you, Ambassador Manor. And it was very interesting to listen to a delegation speaking with such authority. It was a high-level delegation and covering, with expertise, covering all the main issues of concern to us. If we weren't able to pursue some of the issues as much as we're sure you would have liked to, as much as we, not least follow up to the last set of responses, that's in no small measure attributable to the fact that the responses of Israel to our list of issues were simply not addressing many of our main concerns. There is one other state party referred to by Mr. Kalin, which takes a general view of the inapplicability of the covenant to extraterritorial activity, and even that state party, having, once it mentions its point of principle, then gives written responses to the issues. The failure of the delegation to give written responses of course, made it necessary for the delegation then to give oral responses that would already have been there before us, so that the questions we would have then asked would have been follow-up questions rather than initial questions. This leads me to a more general point. The covenant is not a matter of auto-interpretation by every state party. As Mr. Kalin pointed out, this committee is established to interpret and apply, in the context of the review of States Parties report, the covenant. That is reflected as well in various decisions of the International Court of Justice. I noticed two arguments on the issue of the applicability of the covenant. One was absence of extraterritoriality. The other was the traditional Israeli one of inapplicability in armed conflict. Again, the latter one seems to be a totally one-sided and indeed one-country interpretation. The former is shared by two countries. it's not just a question of the applicability of the covenant that there seems to be disagreement on the interpretation. There is the issue of, for the purposes of the covenant, the legality of the settlements. That's to say, it's not for this committee to deal with the general issue of the legality of the settlements, though it can't ignore the fact that the whole of the rest of the world considers them unlawful. But when read together with Article 1 and various other articles, particularly the right to life and right to freedom of movement and so on, one can't ignore that dimension, and they are in very many ways at the heart of the other problems that we've had to discuss. Another issue is the question of torture. Still sticking to the issue of auto-interpretation, the very fact that the state party maintains the notion of a defense of necessity to a crime, a human rights crime, that the overwhelming, the unanimous, I think, view is that there is no defense of necessity to the crime of torture, is if nothing else, asking for a certain amount of skepticism in relation to what happens to victims. I'll come back to that in a moment. The same goes, of course, to the issue of house demolitions. If we're talking international humanitarian law, again, I'm not aware of any interpretation of international humanitarian law that allows for punitive house demolitions. The areas that have been of traditional concern are, of course, the use of force, the use of lethal force, especially during armed operations. I'm aware that, and encouraged by some of what we've heard in terms of possible implementation of possible recommendations from the Turkel Commission. At first hearing Mr. Neumann, I got the impression that everything was so good already that we didn't need any changes. But if I've understood correctly, and I'd be glad to know in the later if otherwise, already the recommendations for the fact-finding assessment mechanisms are being implemented in relation to what happened in connection with Operation Protective Edge. And I see the delegation already nodding, and that's an encouraging dimension. Here at this stage, all it remains for me to notice is that however good a system may be, and its real or alleged compliance with international standards, it's only as good as how it works in practice. It is not an ivory tower question. It's a question as to whether it delivers the goods. I must say I was relieved to hear some of the statistics from Mr. Neumann of apparent prosecutions of, in respect of some military operations, at least on the West Bank. I'm not sure that I've heard of any such activities in relation to some of the bigger operations, such as Operation Cast Lead, and of course it's still early days for Operation Protective Edge. On the question of interrogations, the same thing applies. It is encouraging to hear that at last there is a genuine independent inspection of ISA interrogation from in that it's no longer an ISA official representing the DPP's office in looking at the issues, but it would still it's still going to be important for us to see in practice what the new system can deliver, bearing in mind that it's already stacked against the detainees. 15 days incommunicado detention, even taking on board what I understood to be the case, that there is now no longer the possibility of prolonging even that period. That's what I understood by Mr. Schondorf. If I've got that wrong, I'd be glad to have it put right. But even then, the 15-day period is exorbitant, and it does, in fact, whatever the purpose may be, it does, in fact, create the potential for for very serious abuse. And certainly the information from NGOs, including very respectable NGOs, forget some of the more exorbitant ones that Mr. Schondorf referred to and rejected a little bit earlier, the more standard ones, including the so-called moderate physical pressures that were, except in case of necessity, found to be unlawful by the Israeli Supreme Court, or even just simple physical brutality, the large number of those that have kept coming forward, it's very hard to believe that that they are not happening, and if they are happening, that they're all justified by the defense of necessity, or if so, there's manifest the problems of the defense of necessity. So far, I'm not aware. Again, I'd be glad for future information to tell us if there have been any prosecutions ever of those responsible for interrogation of security detainees in the context by the ISA. The one general issue, conceptual issue, this committee will certainly have no problem accepting that the government of Israel is not responsible for what it's not responsible for. So, no, it is not responsible for those violations that are committed by the Palestinian Authority or Hamas. Quite clearly not. But it is responsible for those violations it is responsible for, that's to say, which are outside the control of the administering, the actual authorities in control, Palestinian Authority and Hamas, but which are within the control of the state party. I note that there's a restriction, that a lot of, let me put it in a slightly different way, a lot of colleagues' questions have indicated a concern with the restriction of civil space. Israel, traditionally a very open and tolerant country, including tolerance of criticism, seems to be, both from the Jewish population and the non-Jewish population, seems to be looking to reduce the space somewhat. And when one looks at when one hears about some of the legislation being referred to, even if it only relates to tortious liability, or something as at least apparently insensitive as the Nakba law, it perhaps doesn't help the impression of full compliance in this case with Articles 19, 21 and 22. There are lots of issues we weren't able to explore together that it would have been good to explore. I remind the delegation that if we've left any questions, if it feels it has left any questions that it wants to answer unanswered, it will be able to give written responses within the next 48 hours. Again, I reiterate Mr. Flinterman's appreciation of a prompt report promptly delivered. That also was very much appreciated by the committee. It will be good if some of the reviews currently taking place, there are always reviews taking place in many states parties, can result in a reassurance, a substantial reassurance being given to the committee during the follow-up process and by the time of the next report. So it only remains for me to wish the delegation safe home, and we look forward to continuing the dialogue by other means. The session's adjourned.
Thank you very much, sir.